Hi, this is Sunil Ramlall. I'm here to share with you this video on illegal environment of business. Regardless of our roles in organizations, being a senior leader, manager, human resource management professional, or an individual contributor, we have to be cognizant of the various employment laws and be able to practice them effectively every day. We are all ambassadors of our respective organizations, so understanding the legal aspect of business is of utmost importance. For example, if we are a manager, we are consistently interviewing candidates so that we understand what it takes to abide by the various employment laws and yet access the information we need in order to make an informed decision. So I'll share with you various aspects of the legal system as it relates to human resource management. I'll share with you a few slides, and hopefully this provides some foundation in which to practice human resource management from especially and keep it within a legal perspective. As we know, the US legal system has three components, and screen is frozen, and I'm not able to share with you that screen. So I will share with you in a moment here. Yes, I do want to save. I'm sorry about that. But let me see if I can get this to share with you now. Yep, here we go. No, I don't want to do that. So about that. So as I was saying, as this is keep going, I do want to continue the conversation and to be able to share with you some of the major employment laws and how we can integrate those within our respective roles. Regardless of here we go, got it. As I said, the US legal system has three branches: legislative branch, the executive branch, and the judicial branch. As of now, with the new administration and so on, there are major changes happening right away within the last 10 days. We've seen some significant changes. Regardless of political points of view and all of that, human resource management has to abide by the respective laws that are in place. One, let's start. Equal employment opportunity. EO is the government's attempt to ensure that regardless of race, color, gender, ethnicity, etc., that everybody has equal opportunity to jobs and be promoted, etc. This stems back from the 1964 Civil Rights Act, Title 7 of the Civil Rights Act, where the changes were made, providing equal opportunity for all. As you look back at the history here, the Equal Pay Act for men and women, and then I mentioned Title 7 of the Civil Rights Act of 1964. We also have the Age Discrimination and Employment Act, 1967, sorry. Pregnancy Act, another one. The Civil Rights Act was amended back in 1991, and then the Americans with Disabilities Act, 1990. Some of the major employment laws that govern our practices within organizations today. According to EOC, which is Equal Employment Opportunity Commission, a disability is a physical or mental impairment, and to quote, substantially limits one or more major life activity. And that hinders our ability to again, substantially limit one or more life activity and sort of prevents us from doing the job. Executive orders prohibits government contractors from discrimination. Government employment policies based on merit and fitness and not any of the factors identified earlier, race, gender, ethnicity, etc. So who enforces the Equal Employment Opportunity? The EOC, and then the Office of Federal Contract Compliance Programs. Within state governments, there are also agencies that help to administer these. For example, in Minnesota, there's a Minnesota Department of Human Rights, where an employee can call and make a complaint and have that investigated if it's deemed to be a feasible, viable complaint, a legitimate complaint, that is. The Fair Pay Act, Congress passed this, basically saying that a legal act occurs when a discriminatory compensation decision is adopted. An employee becomes subject to the decision, or an employee is affected by it, including each time compensation is paid. Three major responsibilities of EOC. Basically, I mentioned this too. Investigate and resolve any discrimination complaints, gather the pertinent information, and issue guidelines. For all of us, this is critical because we could be subject to these types of discriminations, or we could be subjecting people to this type of discrimination. And so it's upon us and all of us within organizations and communities to ensure that this does not happen. From an organizational perspective, there's what we call disparate treatment, then disparate impact, and reasonable accommodation. So let's break these down a little bit. Disparate treatment is basically when individuals in similar situations are treated differently based upon the protected groups. So race, color, religion, sex, national origin, disability status, except what we call the BFOQ, bona fide occupation qualification. There's a job qualification based on race, religion, etc. The employer asserts it as a necessary qualification for the job. So having a female attendant in a women's changing room, of course, that would be a BFOQ. Flight attendants in airplanes, when you have to be tall enough and not too tall so you can reach the bins, the baggage area, and that's sometimes considered a BFOQ. The type of airplane and height factor comes into play also. Disparate impact occurs when a neutral employment practice that you and I may be involved in every day, but it disproportionately excludes a protected group from employment opportunities. So it disproportionately excludes protected groups. So if you're doing layoffs, for example, and you are basing your layoffs on some factor, but then you realize that 4/5 of the individual laid off are women or people of color or age 40 and older, you are basically creating a disparate impact there potentially. And that's what you do not necessarily mean to do that, but whenever we take these interventions in our organizations, we have to ensure that there's not any sort of disparate impact and do the analysis to ensure that we are staying legal there. When we look at the Americans with Disabilities Act, it tells us that we have to make reasonable accommodations for individuals who have been deemed to have some sort of disability. It places special obligation on employer to affirmatively do something to accommodate an individual's disability or religion, whatever the case might be, and making facilities, for example, readily accessible and usable by individuals with disabilities. So having elevators, etc., whatever it might be, it's wide enough that if somebody's on a wheelchair that they can access that. Or alternative to sitting, maybe standing, whatever it might be. Again, reallocating resources, the type of work one is being asked to do, that's all part of making reasonable accommodation. Reasonable, I just want to point out, is when it's not going to provide some undue burden on the organization financially or otherwise to make that sort of accommodation. Title 7 forbids discrimination on the basis of religion, just like race or sex. Religion also receives special treatment, requiring employers to exercise an affirmative duty to accommodate individual religious beliefs and practices. So again, we make some sort of accommodations for individuals to practice their religious beliefs. Retaliation for participation in opposition. Title 7 particularly states that employers cannot retaliate against employees for either opposing a perceived illegal employment practice or participating in a proceeding that related to an alleged illegal employment practice. So we don't, if we view it as an illegal, we can oppose it without the threat or action of retaliation. Look at the nature of our organizations today. We're becoming much more diverse. We are growing in different types of demographics and all of that. Those of you who remember Anita Hill and Clarence Thomas many years ago, remember the coming to light, the whole issue of sexual harassment in the workplace, and how that impacted and empowered individuals, ensuring that there is no sexual harassment in the workplace. There are two types of sexual harassment. One is the tit for tat, and then the hostile work environment. Unwelcome sexual advances, requests for favors, and other verbal or physical contact constitute sexual harassment. Again, quid pro quo, and then the hostile work environment. 4 steps, again, this goes for all of us, regardless of our place of employment or where we will be working, etc. We all should have, organizations must have, some sort of policy statement that describes what is sexual harassment and then consequences. Provide training. It's a must. Reporting mechanism. To whom do you report if there is some sort of incident or discomfort with something? And then prompt disciplinary action. If somebody tells you they just want to tell you, but not do anything about it, of course, you as a manager, you as an HR professional, you have to investigate right away. Even if somebody tells you they don't want to do anything about it, the onus, the responsibility lies upon the organization to protect the rest of the workforce. Excuse me. Safety, we have the OSHA authorizes federal government to establish and enforce occupational safety and health standards for all places of employment engaging in some sort of commerce. Okay, so one of HR's major challenges is legal constraints imposed by the government, and frankly, the respective employment laws have been pivotal in protecting the rights of employees in the United States. HR and line managers need to understand legal requirements and prohibitions to manage in ways that are financially and ethically sound, and in doing so, create a competitive advantage. So we look at our responsibility. Senior leaders, managers, HR, and all individual contributors. It's the onus that we be aware of the respective employment laws. We're able to practice them. For many of us, most of us, we are not employment attorneys, and are not like up to date on the day as the court cases, etc. But utilize resources such as the Department of Labor, EOC websites, and your respective state governments on the various employment laws that protect the rights of employees within your respective states. Legal environment, having all of these laws in place help to create not only a legal environment, but one that's ethically and morally sound, and in the end actually helps with creating financial success, as we do not have lawsuits, we do not have morale being affected as a result of these situations happening within our respective places of employment. So hopefully this provided some guidance on the legal environment of business and able to utilize within your respective places of employment. Thank you for listening, and please feel free to visit my website, www.sunilramlall.com, and we can communicate that way also. Take care. Stay well.